was some discussion of the first sale doctrine, which is the part of copyright law that enables us to do what we do as libraries, or a lot of what we do as libraries, like the core functions, like lending books, for instance. And then eBook licensing and how that sort of differs and interacts with some of the rights that we have come to be, or we've grown accustomed to over time with respect to the first sale doctrine. And then we're going to take a bit of a shift and start looking at the orphan works problem and some possible solutions to that problem, and also best practices for digitizing orphan works and making them publicly available online. So hopefully we'll have time to do a little bit of a active learning exercise at the end and talk about some scenarios, digitizing and making available different kinds of orphan works. Feel free to jump in with questions or comments at any time. No need to wait until the end for that kind of thing. All right, so let's get started. So the first sale doctrine, a good way of, sort of communicating what this is all about is to consider the rights that you have in, say, like a print copy of The Catcher in the Rye that maybe you have to buy for, maybe you bought for like your own reading interest, or maybe you have to study it in high school or college or what have you. Let's say you still have a copy of that on your shelf. What can you do with that copy? Like, what are your rights, for reusing that, and in terms of like the actual physical copy? Yeah.
You can sell it to someone else.
Yes, you can. You can absolutely do that. You can lend it to someone else. You can relinquish possession of it. There's all sorts of things that you can do with it. And this is an interesting point, especially considered in relation to the rest of the content that we've been talking about over the past few weeks, because we've been talking about the exclusive rights of the creator and how if something's copyrighted or still protected by copyright, you have there's limited ways that you can reproduce that work and disseminate it and so on. So this is really touching on something else, like a different aspect of the rights in a work, and we're talking about like physical manifestations of works. So even though you don't own the copyright to The Catcher in the Rye, because you own that physical copy, you have certain rights over like what happens to that copy and how what you can do with it. You're perfectly within your rights to sell it, as Abby said, or lend it, or create engage in any kind of like secondary downstream market for that work. Now, in contrast to that, if you have like an ebook version of The Catcher in the Rye, really it all depends on the terms of the license agreement that controlled like your either purchase or rental of that work. And so we're really going to delve into, for the first half of this workshop, some of the differences between these two scenarios and the implications for libraries in particular. So the first sale doctrine, this has been codified in section 109 of the copyright law, and it wasn't always the case, as we'll see in a moment, but essentially what it says is, notwithstanding the provisions of section 106, which is where they enumerate the exclusive rights of copyright owners, the owner of a particular copy, lawfully made, is entitled, without the authority of the copyright owner, to sell or otherwise dispose of the possession of that copy. And so this is really like what enables us to do what we do as libraries in terms of like our core function of providing access to information, and specifically lending books. This is, at least in the United States, like this is the legal foundation of that practice. So it's extremely, extremely important to us as people who work in libraries and believe in the principles that sort of guide us as information professionals. It's also really important to other, like any kind of secondary market. So this was also, what enabled, for instance, Blockbuster, various like video rental companies to do what they did when they were a thing. And also, downstream sales, like eBay, like all of the things that you can buy on eBay. Much of it is like copyrighted material, but it's someone who owns like a physical copy of that material, and they're just selling that copy. So it's a really important thing. And as I said, it wasn't actually always part of the copyright law here in the United States. So really, where all of this, like the origins of the first sale doctrine, at least in the United States, was the Bobbs-Merrill Co. versus Strauss U.S. Supreme Court decision in 1908. And essentially what was happening here is a publisher tried to control downstream sales of their publications. They wanted to require that anyone who purchased a copy of their books could only sell them for up to $1. And so they wanted to impose basically requirements, regulations, restrictions that would limit downstream markets for the works. Because obviously it's in a publisher's best interest, at least in terms of their profits, to require everyone to purchase a brand new copy of the book, or to pay a fixed price, and to eliminate entirely any kind of rental or resale market. The court said that the publisher did not have the right to enforce those price limits, and their decision was eventually codified as Section 109 of the U.S. copyright law. But the court also mentioned that if this use case had involved licenses, then the decision might have been different. So all of this really comes to a head in ebook licensing, and to a certain extent, licensing for any electronic resources in libraries. Typically, if you're purchasing or licensing an electronic resource in the context of library collections, you're entering into agreement with either the publisher or an aggregator or vendor of that content, and you're not actually purchasing a copy of the work itself. So what this means is that when there's no sale and no actual bona fide purchase, there's no first sale doctrine. And this can be a huge problem for libraries, and has become a huge problem for libraries. So it means that we don't, in many cases, own anything in the books, the electronic books that are in our collections. It severely limits our rights around lending, collection development, preservation, special collections, and archives. And we'll delve into some of the ways that ebook licensing can affect each of those areas. It also, and this is a really big one as well, has the potential to impose additional restrictions and technological protection measures in the form of digital rights management software that can negatively impact usability and a variety of other things as well. And so there's kind of a distinction between the battle that's being waged on the DRM front and the licensing front, but they have many of the same effects. So we'll look a little bit more closely at those. So ebook licensing. First of all, some statistics. So this is from a recent report, Academic Library Use of eBooks. Again, I'll send these slides out so you can click through and see the links. But essentially, this report found that academic libraries spent an average of around $300,000 on ebook contracts and licenses with individual publishers, apart from what they spent on the same with aggregators. And that's a notable statistic, just because a lot of the content that we get in terms of ebooks and whatnot actually does come from aggregators. So this isn't really necessarily representative of the total average spend on ebooks. Also, the report found that for the libraries that were surveyed, they had corresponding print copies for only 25% of the ebooks in their collection. And this is actually kind of alarming, especially when we consider all of the rights that we give up in electronic content when we license it. It means that we're sort of ceding control increasingly over our collections to publishers. And then finally, in terms of licensing practices, only 5% of libraries sampled said that they would definitely not sign an ebook license without guarantees of perpetual access. And flip side of that is that 95% would sign a license that didn't guarantee perpetual access, even though 30% said it would be a very important consideration. So a little bit of background on licenses versus copyright. A license is a contract or a legal agreement that is agreed upon by two parties, and it has specific terms. And licenses can modify, alter, or change the rights that each of those parties would have under copyright law. So increasingly, the licensing of digital content, what this means is that it exists in a realm separate to copyright. We have copyright law, and then we have contract law, and those are two distinct bodies of law. So when we sign a contract and agree to specific terms, that can override the rights that we would have by default under the copyright law. So this can be extremely problematic, as we'll see, shortly. But I also wanted to say it's not necessarily all doom and gloom. There are, situations where a license actually affirms the rights that we would normally have under copyright law. And we'll look at a couple of examples, one positive and one negative. But first of all, just a little bit more on eBook licenses specifically. In many cases, they will attempt to limit users' copies and transmission, or rights to transmit the works. They'll limit the library's ability to loan the works, sometimes by a number of simultaneous users who are able to access it, or indeed the number of circs or loans in the total life of the item. In many cases, they don't allow the library to keep copies for perpetual access. So if you terminate your contract, they pull all of that content from your collection, and you're sort of left out in the cold. Again, all of this is sort of negotiable and depends on the term of the license, but many eBook licenses do have these requirements or variants of them. And of course, none of this is even to mention DRM, digital rights management, which can sort of trump, even if you work really hard to negotiate against these kinds of requirements. And say you manage to get perpetual access rights to the content that you're getting, if then the publisher goes and applies really thorny digital rights management restrictions so that you can't, in practice actually preserve any of the content or copy it, etc., without actually circumventing the digital rights management, then you're in a really tough spot, and all of the effort that you put into negotiating better rights in the license has sort of gone to waste because of the Digital Millennium Copyright Act, which basically says that we have no right as libraries to circumvent technological protection measures or digital rights management. So even if the terms of the license are good, if the content is laden with DRM that prevents us from doing what we need to do, then we're still it's still a loss. So again, to look at a couple of examples, this is just the Amazon Kindle license. You can see it says, unless specifically indicated otherwise, you may not sell, rent, lease, distribute, broadcast, sublicense, or otherwise assign any rights to the digital content or any portion of it to any third party. You may not remove any proprietary notices, blah, blah, blah. What this basically means is that if we were to consent to a license with that kind of language, we don't own the content at all, and we give up any rights that we would normally associate with the first sale doctrine. And we severely limit our ability to share that material except within the parameters defined by the publisher. Now, again, I said this isn't all a story that's just full of doom and gloom. There are some bright lights. Many of you might have heard of the state librarian of Kansas, Joe Butler, who back in 2010, 2011 was renegotiating the statewide library deal for library contract for Overdrive in Kansas on behalf of all of the public libraries. So one of the things, there were two main deal breakers for her. Number one, there was a 700% price increase over the deal that they had signed 5 years before, and also there was sort of a sneaky change in the terms of the old contract. And you gotta love Jo Butler. She was being a rigorous librarian and read all the fine print and picked this up where other people might not have. So in the original contract, there were references to purchasing the content because the consortium is purchased from, I think that DLR's Digital Library was sort of some kind of branch of Overdrive. Yeah, so essentially there's the language is saying that the library had actually purchased that content, not licensed it or rented it in some way. So what Joe Butler did was get together with the Attorney General in Kansas to craft, well, to get a second opinion on the language here, and to look also at the new contract, which said, which had totally removed any kind of language about purchasing the content. And so they managed to mount like a really effective argument that this old contract, that the language there essentially meant that they had the right to transfer all of the content that they had purchased to a new platform, because they weren't going to stand for 700% price increase. So they went back and forth, and Overdrive sent a series of new proposals, none of which was ultimately acceptable. And eventually they conceded and said, okay, we'll give you all of the content, you can move it to a new platform. They put out a call for proposals and found a couple of new vendors, and they moved everything to those new platforms. So as a result of that sort of victory, at least in part, Joe Butler was named Library Journal's Librarian of the Year back in 2013. So sort of a great example of a big win for libraries in this sort of e-books licensing battle. All right, so looking ahead, you might have thought, or might have occurred to you as we've been talking about e-books licensing and the first sale doctrine in particular, why can't we why can't we apply those same principles to digital works? What would be the problem, for instance, with allowing people to sell the MP3s that they buy from iTunes? You might have hundreds of songs from a few years ago that you purchased that you no longer listen to, and you might want to sell them on for a portion of the original cost, and then you can buy new music. In a similar way that you might take a box of old books to a used bookstore so that you can buy some new ones that make space on your shelves. And so a company actually tried to do that and create a technical framework that would enable that kind of thing, and track the provenance of the different MP3s to try and guard against copyright infringement, and enable really a downstream market for digital works. So it went to the district court in New York, and they unfortunately ruled that it was copyright infringement. So it seems that, as in terms of the judicial climate, we're not quite there yet. People, judges in the courts aren't really comfortable with the idea of digital for sale. It's possible that we'll get there at some point, but at this point we aren't there yet. So really, what this all comes down to is, this is a grave, and some might argue, almost existential threat for libraries. Libraries couldn't exist, but if not for the first sale doctrine, or at least that would seriously curtail a lot of the core activities that we engage in around loaning content to our patrons. And so yeah, we're facing a huge threat in terms of ebooks licensing and the practices around that, because they literally do, the intention behind it is really to destroy secondary markets, including those of libraries. And this was foreseen early 20th century, shortly after that case of first impression in the Supreme Court, that eventually were the ruling that developed into the first sale doctrine. Following that decision, there was still a lot of disagreement about whether this was a good thing, the first sale doctrine, and a lawyer spoke to Congress and argued eloquently that doing away with the first sale doctrine would place a weapon in the hands of publishers. He said, effectuate this, and it means that publishers can fix any condition. It could be a condition of price, a condition of who can sell it all. Could be a condition that nobody can sell unless he comes in and subscribes to a code that may determine a man's business and affect his countenance in business, and on and on and on. And we're already starting to see this. There are some publishers who will not sell digital books to libraries because they're either because they're fearful that somehow the content will be subject of copyright infringement, or they just haven't had had time to develop some kind of like business model for it. And then we have all sorts of other crazy business models that don't make any sense and are completely arbitrary and don't serve our users or libraries as institutions. So we've got Penguin, copies expire 1 year after purchase. You can purchase a digital copy and lend it, but then it'll go away at some point in the future. HarperCollins, 26 checkouts limit per copy, and then it goes away. Who knows where they got that number? I mean, yeah, it all seems like really arbitrary. Libraries pay 3 times the commercial price for ebooks with Random House. A lot of this is sort of like public library focused, but still, nonetheless, it gives you a sense of like the spread of different practices that are being promulgated and experimented with, often at the expense of our users and again, libraries as institutions. So the role of libraries in all of this, really to stand up to publishers that impose unreasonable restrictions, to follow the example of Joe Butler, read the fine print and like push back in cases where the terms don't serve us or our users. Indeed, to like band together, develop standards, best practices for engaging in those kinds of negotiations. LibLicense is sort of like a coalition of well, I mean, it started as an email list, but like really, it's librarians who are interested in licensing of any kind and who participate in collection development and whatnot. It's a very active list. They developed a model license agreement with commentary. That's a really important development because it's basically a document that has all sorts of licensing provisions that you could just copy and paste into a license that's under negotiation. And then it has commentary as well, so that when it actually comes to sitting down in a room or like virtually speaking with the publisher's representative, you can provide the rationale for like why this is important and why even it's a deal breaker that we have rights, perpetual access rights, or that there be no DRM or limited DRM on the content. And that, again, I think this is sort of like a start. When you read through it, like there are people with far more expertise than I in this field who have said that this is a great start, but we really need many things like this and even more robust versions of this. So Kyle Courtney at Harvard, for instance, is working on a similar document that would have more provisions and more commentary to better equip librarians in negotiating with publishers and vendors. Definitely avoid licensing content with thorny DRM restrictions, and then you have to be, really astute and rigorous in like looking not just at the fine print of the license, but at the content itself, and make sure that we aren't, giving up important rights through the application of digital rights management. And using the collective buying power of our consortia to apply market pressure. And that's something that we're definitely doing in the electronic journals licensing space. That's happening all over the world, really. Like, especially in Europe right now, there are entire countries that are, at the negotiating table with Elsevier and, some of the big 5 academic publishers, and threatening to, cancel their deals. As an entire country. So yeah, that's definitely an area where we can like bring our market power to bear and try and apply some pressure and enforce the issue. Any questions on eBook licensing? Comments? I know we've got a few people in the room that have are actively involved in collection development here at the libraries, and I don't know, does anyone have any thoughts on this, experiences you'd like to share? Okay, well, you can jump in at the end or whenever, if you have anything to add. All right, so switching gears, we're going to talk a little bit about the orphan works problem. How many of you know what an orphan work is? Okay. Anyone want to venture a definition?
me what it is. I can't venture.
Orphan work is when the copyright and the ownership is no longer known. It's usually associated with a lot older text or sometimes obscure.
Yeah, no, that's a good definition. I'd say there's really two components to orphan works. Number one, it's a work that's still in copyright. And number two, it's a work for which like the owner is either not identifiable or not locatable. So the first part is important because that really gets at why this is a problem. For really old works, like they're usually in the public domain, and so really it's not such a concern, like who created it, because copyright protection doesn't apply, and you can reuse that material without permission. For material that's still under copyright, however, you generally need permission for like a lot of different uses of the work, and so that's why it's a problem if you can't identify, the person or organization that you need to go to get permission, because it effectively like stalls any attempts to reuse the material, or in the context of libraries, this most often comes up in terms of like providing access and preservation to copyrighted materials that are in our special collections and archives, but also more broadly in our collections more broadly. So another part of the reason why this is a problem is that like the volume of orphan works worldwide is just massive and kind of staggering. So even for published works, like Carnegie Mellon University Libraries did a bit of a study of its collection and looked at all of its published works and tried to, or a sample of them anyway, and tried to determine like for how many of them could they actually identify the publisher. If they needed to get copyright permission to create copies for preservation or access, would they be able to? And they found that for nearly a quarter of the collection, the publishers were no longer in existence. They've been dissolved somehow, ceased operations, and when that happens, it's like there are any number of scenarios that could be in play there. In some cases, like the rights are reverted back to the authors. In other cases, they transfer to like the managing editor. Sometimes publishers are bought up by another publisher, and then that can happen again and again, and it's like, and often, bad or no records are kept. And so it can be literally impossible to like locate someone who will actually give you copyright permission in cases like that. GISC, which is a UK institution, did a survey of like 503 sort of cultural heritage organizations, including libraries, museums, galleries, and archives. And in terms of like the responses to that survey, they estimate that up to 10% of museum and gallery collections and up to 20% of archival collections consist of orphan works. Just in terms of the responses and like the estimates of these different organizations as to like how many orphan works they had in their collections, they estimate that like over 50 million orphan works just amongst those institutions. 26% of those institutions reported like frequent legal difficulties just trying to maintain and manage their collections. And as like kind of a an indicator, 40% of the British Library's copyrighted works are orphans as well. So some common examples of orphan works. Certainly lots of orphan works from local history collections, including like rare out-of-print volumes and newspapers are common orphan works in that area. Federal history, it's just laden with orphan works. You might not think that. And of course the federal works here, or works of the U.S. federal government are, it's commonly known, in the public domain, sort of like released into the public domain as they're published, but unfortunately in many cases like the federal government actually contracts out to third parties in order to create those reports or what have you. And so a good example, the reports of the Public Land Law Review Commission. This was essentially like they contracted out to all of these third parties like the work of developing recommendations for a major overhaul of federal public lands legislation in the 1970s. And as a result of that, like because those reports were created under contract and copyright wasn't transferred to the federal government, it's literally impossible to get permission for those works, because in many cases, like those those private firms and whatnot are no longer in existence. There aren't records of like exactly where the copyright lies, whether it's with the federal government or with these private firms. And when there aren't any records, then that makes like even that makes the government like resistant or reluctant to grant permission, even because they can't say with any confidence that they actually own the rights. And that's a really common scenario with orphan works, is that that's what it comes down to. Records weren't kept, or the records weren't complete, and so the organization that you think might own the rights can't say with enough confidence that they do, and so they won't grant permission. And then it just kind of stalls, and you don't really have any recourse to pursue in order to move forward. We will look at some potential recourses that we can use, but there's no procedure, no official procedure for like how to proceed in cases like that in the U.S. For published works, we've talked about publishers go out of business and so on, and that creates problems. In ephemera, Kelly, you were just mentioning that these are like some of the most common examples of orphan works, especially in archival collections. Like the photograph that might be in an archival form, and there's nothing on the back of the photo in terms of like the date or who took the picture or where it was taken or anything like that. And obviously you can't see the photographer because they're behind the camera. So it's like those are really notorious examples of works for which like it's almost impossible to tell who owns the rights to them. Video footage as well, home videos and things like that, shot by people who might have passed away with no will and no known heirs. It's really, really difficult to determine who owns the rights. So some possible solutions, and we're going to talk like blue sky first, and talk about like some sort of like broader legislative solutions predominantly that might come to pass in the next like 20 to 30 years, because this is an active subject whenever like copyright reform discussions take place. The orphan works problem like figures prominently in those, and there are lots of potential solutions, some of which we can take from our own like history, and others that we could borrow from other jurisdictions. So one potential solution might be this idea of like orphan implied consent. And implied consent is really like a legal concept that is maybe more fully fleshed out in other bodies of law, and hasn't really been like applied in copyright law to a great extent. I mean, there is to some extent, like it's been mentioned from what I know, like mainly in the context of works being published online. The idea that like if you're putting something on a website, then you're providing at least like implicit consent that other people are going to access it with their browsers, and those browsers may create copies and so on. But for orphan works, one analogy might be when you look at like healthcare practitioners. If someone's seriously injured and unconscious and not able to, or like out of their mind for whatever reason, and not able to like consent to medical care, if they desperately need medical care, then the healthcare practitioner has a privilege to provide that, and it's not considered like battery or whatever that they're providing that care. So why couldn't we extend at least like the same logic to information professionals, and that when we're presented with a work that is at risk of like disappearing entirely and being lost to future scholars and educators and so on, and we're have been trained to sort of take control in a situation like that. We know all of the strategies and best practices for ensuring that there's long-term access and preservation for that work. Why couldn't we have the privilege to provide that care to the work? It's just something that, this is probably the most blue sky of all of them, just because it's mostly theoretical right now, but still an interesting idea. Another idea from trademark law, and this is sort of another branch of intellectual property law, but essentially if you stop using a trademark, then you lose all rights to it. And so, in the past, if we look back far enough in the legislative history of copyright, the duration of copyright was actually much shorter. As short as 14 years or even less than that. So it's gradually been expanded and extended over time, and that's only contributed to the Orphan works problem. But while we've expanded the duration of copyright, we haven't implemented any measures to sort of deal with this situation that happens when someone hasn't published the work, they aren't capitalizing on it in any way. Yeah.
Who's keeping track of the trademarks that have ceased to be used for a certain amount of time?
The U.S. Patent and Trademark Office.
So they constantly contact. How do they do that? Do they?
Well, I mean, it'd be more there's so if you had a trademark and then
renew?
More if someone else wanted to use that trademark and then you took them to court in process of legal discovery and each side presenting evidence, the person or the body entity that had appropriated the trademark could say, look, you haven't used this for 5 years. Here's the proof. You don't have any legal standing to to take us to court here. So that's sort of a lot of the times there isn't a central authority that's monitoring these things actively. It's more it comes to a head when people actually file a lawsuit. But could we not apply the same logic to the Orphan works problem? And especially given that, using the same logic again, an orphan work sort of embodies a market failure. One of the purposes of copyright, in addition to promoting the progress of the sciences and useful arts, is to ensure that copyright creators, have some kind of incentive and ability to profit off of the works that they create. But if it's an orphan, in almost all cases, it's no longer, it's sort of outlived its utility value in the market. You literally can't identify who the owner is, or you know who it is, but you can't locate them. And so in cases like that, there's a strong argument that that represents a market failure, especially for orphan works that haven't been registered, where the copyright hasn't been registered with the Copyright Office. And that brings us to the other possibility here, which is to borrow from patent law. So the idea with patents is that you have to file a patent application in order to get, and it has to be approved before you get patent protection for your invention. It's not that way with copyright, as we've seen in past workshops. Copyright's automatic, right? As soon as you create something that enters a fixed form, and you translate those ideas in your head into a Word document or an illustration or what have you, once it's on paper or in an application somewhere, then copyright comes into effect and it's automatic. You don't have to register your copyright in order for that protection to be valid. But why wouldn't we bring back the requirement that you just need to register your copyright? At least, and there are valid reasons why we wouldn't. Certainly it would go against international treaties and conventions like the Berne Convention, which has over 160 countries that are signatories. Basically did away with formalities and says copyright, it should be automatic, and so that is sort of where a lot of this comes from. But it's created this massive problem, and one of the solutions would definitely be to ask that copyright owners, if they expect to profit off of their work and they want copyright protection, to register that work with the U.S. Copyright Office. They already have to do that in order to have legal standing to sue. So copyright protection is automatic in theory, but if you really want to protect something, you should register with the Copyright Office, because if someone were to, yeah?
Sorry, I need to interrupt you in seconds. I didn't know that you had to register to sue. So it doesn't matter what time you register, as long as you can prove the copyright is the one
Yeah.
So is that kind of like the poor man's copyright where someone would mail themselves a manuscript and then not open it?
Yeah, I mean, yeah, that would be good evidence that you had, that you were the original creator. I mean, usually, and I mean, I won't say usually, but like most of the cases that I'm aware of, it's usually, you know, the creators bring a lawsuit related to infringement of the work, and the infringer isn't, or you know, the claim, supposed infringer, alleged infringer, isn't necessarily claiming that they wrote the work, just that that their use of it didn't constitute copyright infringement. So yeah, disputes over authorship, that's one area where it would be helpful, but it's more just that like you need to be able to demonstrate without like a shadow of a doubt that you are the legal owner of that work in order to have standing to sue, and certainly in order to be liable for, or you know, to have the chance of getting statutory damages, which is what like most, what is certainly something, like given that bringing a copyright lawsuit to court costs like upwards of $30,000, you kind of don't undertake that unless you have a chance of getting statutory damages for your trouble. So yeah, this would be one potential solution. Another possible thing, so if we look north of the border in Canada, they have a federal Orphan Works licensing scheme. Essentially, their equivalent of our Copyright Office, the Copyright Board of Canada, they have like a form that you can fill out essentially. And so you just demonstrate in that letter that you send to them that you've conducted a reasonably diligent search. You like list the places that you've looked and like the actions that you've taken. And then they review each application, and if it checks out, then they'll grant you a license to use the work. And they post, you know, keep records of all of the permissions that they've given. The problem with this is that, you know, there's only 30 million people in Canada, and it's not, unlike the States, it's not like, you know, the home of big media and whatnot. So while this is, and this works only just in Canada. Like in order, you know, if you want to get permission this way, it takes like 6 months at least. So I have no idea, you know, I strongly suspect that the U.S. Copyright Office, unless they, you know, were funded, you know, much more strongly than they are now, they wouldn't be able, that this wouldn't be a scalable solution to the United States. But it's one idea. Embracing risk. Okay, so risk exists at all levels. You know, there's so many aspects of like running a library and engaging in, you know, lending and borrowing materials, and like, you know, virtually like all of the activities that we engage in, there's an element of risk involved. You know, certainly providing a space, even like for people to, and we know this like more than most places at FSU, you know, having been the victims of like well, a really nasty incident like a couple of, what is it, 3 years ago now, approaching that, 2.5. And so yeah, I mean, risk exists at all levels, and why should we be like so uncomfortable about risk with respect to intellectual property and copyright, and yet comfortable, relatively comfortable with like all of the other risks that we undertake? Okay, so some of the, I mentioned that we were going to like get practical at some point, so this is it. Harvard has what they call like the Orphan Works Project. It's like one of their initiatives, and one of the like major publications that's come out of it is this report, Digitizing Orphan Works: Legal Strategies to Reduce Risk for Open Access to Copyrighted Orphan Works. And this is like just a really superb document. And it's an attempt to, similar to the statements of best practices for fair use that we've looked at in previous sessions, this just aims to like articulate some of the current practices that libraries engage in order to mitigate risk when digitizing orphan works and providing access to them, and then also some of like the other legal arguments that they could draw upon in order to mitigate risk. So just drawing shamelessly from that publication, here is a list of like you know, good practices for mitigating risk. Certainly relying on fair use and related best practices, and I have a link there to the Society of American Archivists statement of best practices on orphan works. which is a fantastic document. Like if your work leads you at all to have to undertake like limited searches for rights holders and to try and track down who to request permission of. This includes like, well, first of all, a really succinct overview of like what we've discussed so far, but then search strategies for identifying the creator of the work, and you can see all of the strategies that they outline. And then also identifying the rights holder, because obviously the creator is not always the rights holder, and then locating them as well. So it's a really comprehensive guide to engaging in that kind of work. Certainly conducting limited searches for rights holders before making a use. That is sort of required even just to like determine that the work is an orphan. But it also helps to like demonstrate that you've done your due diligence in at least attempting to track down who owned the work. You can focus your digitization efforts on unregistered works. And as I said before, if a work is unregistered, then the owner of that work you in digitizing it aren't going to be liable for statutory damages because it was an unregistered work. You can publicize the project in advance to inform potential rights holders. So again, this is sort of like the idea of providing like a notice period. And you can target specific groups. Some digital projects will do this by putting up a web page on their site that talks about like the copyright implications of the project, the fact that maybe it was impossible, or within like it was unreasonable, impossible with the resources that they had to identify everyone and conduct like a really exhaustive search, and then send the link to that to, or talk about it in newspapers, or publish in press releases. Send out notices to like listservs and so on, depending on like what the material is and who the potential rights holders might be. But again, all just to demonstrate that you've done your due diligence and made a good faith effort to either contact or notify the people who might own the rights in the works that you're digitizing. Certainly publishing a statement on the material or on the website. Noting to users that you were unable for whatever reason to identify all of the owners, and indeed inviting any owners who might be viewing the material to get in touch with you and provide more information. And a big one is implementing the notice and takedown policy. So the idea there is that under the Digital Millennium Copyright Act, if you have the right language on your website and the right policies and procedures in place, if someone were to notice that their material had been made publicly available without their permission, you would be they would have to issue with a takedown notice, and then you'd have 48 hours to respond. And if you take that material down within 48 hours, then there's no risk. There's no the rights holder would have no grounds to take you to court. So that's a really strong, robust protection that we can avail ourselves of. Another example, obtaining permissions through quitclaim grants. This is a kind of an interesting one, which according to the Harvard report is underutilized. But the idea is like, remember the situation we were talking about earlier with like the federal government reports that were sort of created by a third party, and we were saying, if the government didn't keep good enough records of who owned the copyright, they are going to respond to any request for permission with, well, we really don't know who owns this, so we can't grant permission. So a quitclaim grant is basically saying, okay, that's fine. We understand you can't formally grant copyright permission, but if you own the rights, if you happen to be the rights holder, would you condone this use? And so it's not technically copyright permission, but again, it's evidence that you've done your due diligence, and it's also proof that, it's kind of a tangential permission insofar as you have in writing that they, agreed to condone the use that you're making of the material. So that if at a later date, it transpired that they found some records that indicated that they were the copyright owners, that it would have already established that they had provided permission, some kind of permission. So the other thing is kind of another blue sky idea, obtaining permission through like broader agreements. So in the EU, they have like a memorandum of understanding that was developed by cultural heritage organizations and you know, publishers and so on, where they came to an agreement basically on like guiding principles for digitizing works that are no longer in market, that are out of print or, you know, otherwise orphaned. So that kind of thing, you know, would clearly be a massive undertaking, but also potentially on the cards for the future if a similar effort, you know, could be undertaken here in the States. Okay, so we got about 5 minutes, which I think is just enough time. I'm going to break you up into groups of 2. Abby, Jesse, is that okay? And Sarah and Sophie. I'm just going along here. So I guess Rachel and me, and Kelly and Buck. Is that okay? All right. So I guess we got 5 groups. I'm just going to say each group pick the one that you like the look of, and talk amongst yourselves like about like what are the risks involved in digitizing these works. And we can even like, I haven't provided you with a whole lot of detail here, but you could say, okay, let's say we're an academic library looking to digitize this, or we're, you know, a public library or a state library or what have you. And then think about the risks involved and what strategies you would use to mitigate that risk. And in 2 or 3 minutes, I'll ask you to report back to the group.
Hope you just roll over. Which one do you want? When it was donated.
Yeah. And there were copyrighted works that you plus 7 years old. But because we're saying this is more
ideally, when it's donated, the archive should have had some kind of consent form that's like, we can digitize this and stuff. Yeah. Ideally, that's but
I guess, yeah, you could. And they said no, it would be that's an
for that,
I'd love to give you a little bit longer, but we've only got like a couple minutes, so I was hoping we could just go through the report backs. I'm going to start down at the end.
So we were talking about a few different things. The content of the contract with the graphic designer and the terms of the contract would dictate who the owner of the land charts were. And ownership would have been the graphic designer of the city government. Then the city government had a public, if all of their documents and the presentation of all of their findings and data and charts was, in the public forum, then would that necessarily be, would they have even talked about copyright at the time? And then we were talking about the land charts themselves, the question of what might be, you said Creative Commons license, like you could have digital access, but maybe not reproduce for proprietary means.
For Orphan. I can't remember the terms for Creative Commons, but essentially it gives the ability to use it for profit use.
Yeah, those are all good strategies. I mean, the Creative Commons thing is an interesting one because at least like according to the terms of it, like only the owner can apply a license. So I feel like it would be wonderful to, if we could have, that would solve the problem too. If we could just, actually that should be part of the legislative solution, is that like as a requirement that we have the right to stamp Orphan works with a Creative Commons license, or that they enter the public domain. But I mean, if they're, I think the Creative Commons license would be a more elegant solution, because it would still be under copyright and you'd still have to attribute it insofar as you knew who to attribute it to. Anyway, yeah, that's great.
We also discussed number 3. We had a very similar conversation about determining who would own the rights to said land charts, and we also said it had to be between the graphic designer or whatever government representative was a part of that contract agreement. And we discussed how in the contract you would probably look up the contact information of who's a part of that agreement, and then contact both graphic designer and government representative for our due diligence to mitigate risk. And if there was no response, we could also try to do as the document, the SAA document you shared, which is the takedown strategy. So we put it up, and if they contact us finally, then we can take it down within 48 hours to mitigate risk. So those are our strategies.
Yeah, excellent. Did anyone not do number 3? Okay.
We did number 1, and we kind of talked about, well, there's far less risk because none of these have been published, so there's very minimal risk, depending on how long we've had them. But we talked about finding records, like see who donated the items, and maybe trying to get in contact with the donor, or find out who the owner was, or previous owner, and if we get no response, we at least have the records of trying to get in contact with these people. So that's how we would mitigate further risk.
Yeah, those are great strategies, and a really good observation about the risk being inherently lower. A good sort of rule of thumb for mitigating risk is like we were discussing in the other group, who's going to get mad about this rule? Or question, like ask yourself, who's going to get mad about this? And like, so you have to look at the content the photos and the letters, and that was something else that came out. It was like, what if the letters are totally scandalous and like portray someone in a really bad light? Then that increases the chances someone's going to get mad about it.
But then why would they ever donate it to a library? Like, whatever.
Who knows? Yeah.
The person that donated it might not be aware of what's in it. They might just say, oh, I have these boxes here.
Yeah.
Okay. I would do it if they don't like the person.
That's your attic. See,
Those are great. I'm sorry I didn't have more time to elaborate, and I'm sorry I've already kept you a little bit over time. In the summation, I think like a good thing for us to walk away with is that like we need to be comfortable with managing risk as information professionals in order to like fulfill our mission. And some takeaways about that, remembering that infringement for an unregistered item is limited to actual monetary damages. You're not liable to statutory damages, and even beyond that, what we've talked about in past workshops, that as employees of nonprofit educational institutions, we also aren't liable for statutory damages, even for registered items, if we use them in a way where we have like reasonable grounds to believe that it was fair use. So we should be willing to make copies for researchers, and to open up our collections and make it possible for them to get copies for research and private study. And we definitely do that, through interlibrary loan and document delivery, and special collections and archives. We do that too. We should also, use the exceptions that exist, Section 108, fair use, and be aggressive about fair use in particular, and avoid practices that put us at greater risk. So thank you very much. I'd be happy to answer any questions, but I imagine most of you probably need to head home soon. Yeah.
So as a result of this 4-part series, do you have some kind of electronic toolkit available to us, either